My name's David Apol. I am the General Counsel for the Office of Government Ethics, and I'm joined today with Seth Jaffe, who is the Chief of the Ethics Law and Policy Branch. And we are going to go through the Standards of Conduct Amendments with you, give you kind of an overview of how they're going. Before doing that, I don't have to, but I am going to thank the team that worked on this. I'm not going to thank everyone. We'll talk about this later. This has been a very long project, so we've had people coming on and off the team, and that is beyond the capacity of my memory at this point. There's more and more beyond the capacity of my memory at this point, but the lead of that team was Kim Sikora-Panza, who just did an amazing amount of work on that, and we're incredibly grateful to Kim for the work. She was joined by Christy Chung, Margie Levine, Lorna Syme, and Leah Stromberg. So give those guys a big hand. They're the ones who did all the work on this. We just get to sit up here and look wise and thoughtful. But all right. The standard of conduct is long. I looked at the red line. It's 110 pages long. So on page one, no, we're not going to do that. You will notice on this, as we go through these slides, we are violating the first rule of PowerPoint. They have lots and lots of writing on them. That's because there's comparisons on here, a lot of detail on here. The slides are going to be available to you on the IEG website along with this presentation, and so they will serve as a reference document for you going forward, not just to guide us through this program. I didn't see him get up, and suddenly there was a person behind me. Yes, this reminds me. Thank you, Seth. I insisted that I was going to stand at the podium, and then I forgot to do so. So I'm going to go to the podium now. All right. Where is it? So these will be available on the IEG website and along with the presentation. We are going to run through the entire presentation over the first 45 minutes, and then we're going to hold questions and answers to the end because we're going to have the presentation in the library. Question and answers will be streamed, but will not be retained in the libraries, just so that we can have a more vigorous give and take on that. I am going to be covering, or Seth is going to be, after I finish this introduction, Seth will be covering the global changes that are being made and subparts A through D. I will be covering E through H. Okay. So the standards of conduct are sometimes opaque. Okay. The standards of conduct were last major rewrite of the standards of conduct was in 1992. That's a long time ago. There have been a few changes here and there since that time, but now we're rewriting them again. Now you will note that the 2024 date has been strategically placed to obliterate the actual date of the standards, the reissuance, because they haven't been issued yet. But they are going to be issued. We expect them to be issued in April. They have been approved. They have completed their approval cycles. OMB has given us clearance to publish them, and we're now going through the process of that, which involves making sure that all the semicolons are in the right place and things like that, and satisfying the Federal Register Office that we've complied with all their rules. That can usually take a week or two, and once that's done, you will be seeing the standards of conduct come out. At that same time, we will be issuing a legal advisory that will kind of give you a roadmap to the most significant changes that have occurred in the standards of conduct. So you'll have that to help work you through it. Okay. How did we get here? A bad joke just came to my mind. I'm not going to use it. Hopefully that judgment will continue. Well, in we've been at this for a while, actually. We started this in 2014. We knew that the standards of conduct, a couple sections of the standards of conduct needed to be rewritten. The gift section really needed some updating, and most urgent was the rewrite of Subpart F on negotiating for employment, because the Stock Act had come into place. So we had to put the notification requirements of the Stock Act in Subpart F. And at the same time we did that, we did a kind of a major deep dive into Subpart F and Subpart B. And those were published, those final rules were published in 2016. While we were pushing on that, the modernization proposal, well, after 2016, we had a transition that we had to go through, or it was our privilege to go through, and that was the focus of our work during that time. But the most recent kind of surge in activity has occurred since 2022. And we've been, in 2022, we completed the OGE, or the EO 1286 process. Now, of course, prior to that process, the 1286 process is the process where agencies formally get to give us their input. Of course, prior to that, we have been talking to you folks a lot. You'll recall in our, long ago, maybe you won't recall, but in 2014, we had a summit where we had presentations on the ideas we had for this and got some of your reactions to those ideas. We didn't do some of those ideas based on your reaction. We did some other things that, reflected your input, but the point being, this rewrite has always reflected a lot of input from you guys. In February of 2023, we published the proposed rule. We got 19 comments on that from both you and both from the public and the agencies. And here in order to get this reg through, I had to make a promise to OMB. OMB actually likes agencies to make their comments in the 866 process rather than in the public comments. That's part of the deliberative process. I promise that in all future regs, we will continue to give you lots and lots of opportunities to comment, but they got grumpy about some of the comments that they actually agreed with many of the comments the agencies made, but they were a little grumpy about the fact that the agencies were doing it in a non-deliberative fashion. So just remember that is going on, and your chance for real input is prior to the proposed reg. Now you get a second chance of input, of course, and you had that this time when we respond to the proposed reg comments. Then you get to see the final reg before it goes forward, and we get to get your comments on that too, and we have to consider all those. So that's how we got here. In March, actually it was from December to March this year, we were engaged in a lot of negotiations resolving those comments from agencies during the second 12866 process. So at the end of the day, what are we doing? Well, first of all, what aren't we doing? We are not totally rewriting the standards of conduct. This is, there's not huge substantive changes, but we are doing some significant things. We are incorporating the guidance from LAs that has been given on the standards of conduct so that someone reading the standards will have a pretty good idea what they actually mean and how we've interpreted them. And I'll talk about that a little bit more when I get to the outside activity areas. Reflect some of the practices OGE has had in interpreting the regs, so that becomes apparent on the regs. And improves readability. I know almost impossible to think that that is doable, but there are some pieces of the reg that we've heard people had trouble interpreting, so we've tried to make them more readable, and we've added a bunch of examples. On things that we didn't have before. Social media is a good example of an example, and other areas. And examples to also clarify what some of the advice we've given in the past is, and we'll be talking about those. Although there's not a lot of substantive changes or We are going to delay publication. After it's published, there will be 90 days before it becomes effective. This will give you all time to incorporate the changes into your training and highlight those changes if you think that's necessary for any of the changes that we are making. So with that, I'm going to conclude. I'm going to finish up my opening remarks and turn it over to Seth to cover the global changes and parts A through D.
Thanks, Dave. I'm Seth Jaffe. I'm the chief of the Ethics Law and Policy Branch, and I'm going to be going over some of the global technical changes that occur throughout the Standards of Conduct Modernization and Final Rule that's coming out hopefully in the next couple of weeks. And I'm also going to be going through subparts A through D. And to echo what Dave said, this is not a complete rewrite of the Standards of Conduct. It's what we're calling a modernization. And I will say that the technical, non-substantive changes combined with the actual substantive changes that are included in the standards, we think really improve the readability, improve the logic of the standards, and we really think people should not have a difficult time implementing these. In fact, our intention is to make the standards of conduct more easy to implement from an ethics official's perspective. So we certainly think that's the case. I guess you can be the judge. So I'm going to start with the global technical changes. These are the changes that occur throughout all the subparts of the modernized, updated standards of conduct. They're not unique to any particular subpart. So first, we removed the gendered language and language that unnecessarily focuses on marital status. Again, it's been since 1992 that much of this has been updated. We made some punctuation and capitalization changes for consistency. We replaced certain terminology, such as disqualification and disqualify, with recusal and recuse, because that's consistent with the changes that we made in Subpart F in 2016. We also updated agency names. Agencies come and go, their names change, so do regs and laws. So we updated citations to outdated regulations or non-existent regulations. We also modernized various examples to remove outdated language. And in addition to that, we've also introduced examples that address topics that didn't even exist in 1992. I don't think there was such a thing as social media in 1992. So we added many examples throughout that address updated topics, such as the application of the standards to the use of the personal use of social media. I know Dave will be talking about that in a little bit more specificity when he talks about Subpart G and the misuse of position updates. So let's start at the beginning. Let's discuss briefly Subpart A, or the general provisions. There weren't many changes made to Subpart A, but there is kind of one modernizing change that I wanted to highlight, and that's to General Principle 13. So we updated the list of equal opportunity laws to include pregnancy, gender identity, and sexual orientation. We added genetic information, and we replaced handicap with disability. So when you look on the slides in front of you, the highlighted language in yellow is the new language. That'll be true on this slide and slides coming up. And basically, these changes are just meant to reflect the categories that are now identified by the EEOC as covered by federal anti-discrimination laws. We also made other kind of minor technical ministerial changes to Subpart A. Okay, Subpart B. Let's talk about a couple of amendments that were made to Subpart B, gifts from outside sources. Now, as Dave mentioned, Subpart B was significantly rewritten in 2016. So as a result, there weren't any large substantive changes to Subpart B that were part of this project. However, there is one kind of modernization amendment that I want to emphasize over and above the other technical and ministerial amendments. And one technical change was to the WAG exception at 204G2. It's really to improve readability. So we're updating the structure of G2, which defines when a gathering is widely attended for the purposes of the WAG exception. And specifically, we're just organizing the components of the WAG definition at G2 into new separate paragraphs at G to 1 little I, 2 little I, and 3 little I. And this is really not a substantive update, but I wanted to mention it because when you look at the actual language that's on the screen behind me, you'll see that the definition looks very different. Although ultimately, there's no substantive change. We thought that based on feedback that we've gotten, that we really believe that this kind of simple change will really makes the requirements of a WAG much easier to find in the regulation, and it also makes it clearer that these 3 elements are all required to qualify for the WAG, as opposed to any one of them just in the alternative. Okay, now let's turn our attention to Subpart C. That's gifts between employees. And we did make a few more changes here in Subpart C than we did in some of the other subparts. Subpart C is interesting in the sense that, it's not been updated since 1997. And unlike many of the other subparts in the standards of conduct, OGE is constrained in our ability to give guidance on gifts between employees because there is a statute that governs this area, and that statute is 5 U.S.C. 7351, gifts to superiors. But we did make several changes so that we did also clear with OLC at the Department of Justice changes that we were able to make. There were other changes we considered, but we're informed we're not consistent with the statute. So the changes that we did make, first, some technical changes. Second, a change to the special infrequent occasion exception. Third, making it clearer the limitations on supervisors' ability to accept a gift from a subordinate. Fourth, the ability of a supervisor to give a gift to a subordinate who receives less or more pay. And fifth, the disposition of prohibited gifts between employees. So first, a couple of technical changes. We replaced donating and donation with contributing and contribution. Thought that was more appropriate. And on the screen here, you'll see that we added a new example. Now, this example is consistent with our previous interpretations of the regulation. This is not a change to the regulation, but the new example makes it clear that a pre-existing personal relationship does not supersede the restriction on giving gifts to supervisors. So an employee, subject to the exceptions that do exist, can give a gift to a supervisor if it meets one of those exceptions, such as de minimis, below $10 and not cash, but a personal relationship outside of work is not one of the applicable exceptions to give a gift to a supervisor. And this example just kind of makes that very clear in the reg. In addition, we also added a category of a special and frequent occasion to the list, to the non-exhaustive list of special and frequent occasions to include bereavement. So bereavement is a special infrequent occasion underneath regulation now, and that's there. And in addition, we added a new example illustrating that milestone birthdays are not infrequently occurring occasions subject to the exception. This is consistent with what we've said before for years. Someone's 30th, 40th, or 50th birthday is not treated any differently for the exemption as any other birthday. Okay, let's talk about gifts to superiors. Bad idea. But gifts to superiors should not accept, knowingly accept, a gift from a subordinate unless an exception applies. Now, this seems like a really simple and straightforward idea. However, in the regulation prior to our update, there's no explicit statement of this in Subpart C. So Subpart C has always stated that under 302, that employees should not give gifts to a superior. In the modernization updates, we are expanding this concept to similarly note that a superior should not accept such gifts, thereby making the restriction reciprocal. You can see the highlighted language on the screen here where it says, and an official superior may not knowingly accept such a gift. That was not there explicitly before. It is now. We think that this update is appropriate to make it reciprocal because it's consistent with this type of issue as it relates to accepting or giving of gifts in Subpart B. So gifts from employees receiving less pay. This often, I think, causes some consternation in the application of this, but this comes from the statute. That's why there's such a provision in the first instance. But we're updating the language of this, of the exception that was in this subpart. In the current regulation, an employee can accept a gift from another employee who receives less pay if there's a personal relationship to justify the gift. Now, when it was a superior, subordinate, that exception didn't apply. That exception does apply and did apply to employees who receive less pay. And the two employees are not in a subordinate official-superior relationship. And this is regardless of whether the gift recipient is the subordinate or the official superior. And we believe that this phrasing is broader than necessary to address the key concerns that we have when there are gifts between employees. And the key concern is if there's a gift from a subordinate to a superior. So we're updating the section, exception to more precisely state that the employee receiving the gift must not be the official superior of the employee giving the gift. The other pre-existing conditions that are required for this exception to apply still apply, such as a pre-existing personal relationship. Now, we're also updating this section to categorically exclude gifts from a superior. So in practice, the standards have not restricted most gifts to from superiors to subordinates because most subordinates receive less pay than superiors. But since 1992 and some evolution of pay systems, that's not always the case anymore. So if you look at the last highlighted language on the slide, it says that the employee giving the gift is the official superior of the employee receiving the gift. That's what is permissive. So ultimately, for example, what this means is under the new regulation, if there's a new superior, comes into an office, and the superior wants to take their employees, their subordinates, out to lunch and pay for it, the superior can do that and make the gift, and the subordinates can accept the gift even if they receive more pay than the superior. So, let's see. Sorry, just, and we're still on, is this in disposition of gifts? Okay, so Subpart C, disposition of gifts. This is a new subsection. So this is not just, a tweak to the existing rule. This is a new subsection. And, over the years, we've been asked by ethics officials about appropriate ways that employees who receive improper gifts can appropriately dispose of those gifts. And during the 60-day comment period from the proposed reg, there was an agency that suggested that we give guidelines on how employees should dispose of improper gifts they've received from another employee. So consistent with the guidance that we provided in the past on this issue, so this isn't a change, we're adding the new section 305, which notes that Subpart B, so gifts from outside sources, Subpart B disposition provisions may be referenced when determining how to dispose of a prohibited gift under Subpart C. So these disposition methods are required in Subpart B for things like gifts of tangible items, gifts of perishable items, gifts of intangibles, and those are right there on the screen. And those are required methods of disposition under Subpart B. Subpart C does not make these methods mandatory. It just says that employees and the agencies can refer to those methods. So the new section 305, it's on the screen here, says paragraphs A1 through 3 of 2635.206, referenced also on the slide, may be referenced when determining an appropriate disposition of a gift and may not be accepted under this subpart. So it's not required, but we do think that, of course, if an employee or an agency decided that in a manner consistent with Subpart P disposition, that a Subpart C improper gift would be disposed in the same manner, that would be fine. But OGE believes that agencies and the employees should have a little bit more flexibility in determining the appropriate manner to dispose of a gift that's not a gift from an outside source, but is a gift from another employee. Okay, Subpart D, conflicting financial interests. Now, we've made some minor technical revisions to Subpart D. There's no major rewrite or even any substantive change to Subpart D. However, I just would note that over the years, I know it's happened to me, and I've been asked a lot from ethics officials and even from people within OGE, but what the relationship is between the Subpart D, standards of conduct, financial conflicts of interest regulations, and the implementing regulations at Part 2640 of 18 U.S.C. 208, because they cover a lot of the same ground, even though the Part 2640 regulations cover more ground. There's a large overlap in just the basic elements of what can create a potential financial conflict of interest. So at the beginning of Subpart D, we added this new language that's in yellow here, and it starts out by saying, Part 2640 of this chapter interprets and is the implementing regulation of 18 U.S.C. 208. So it makes it clear that the introduction to Subpart D, that Subpart D are not the implementing regulations of 208. This subpart, Subpart D, summarizes the relevant statutory restrictions and some of the regulatory guidance found there. So we do think that this new language should clarify a little bit the relationship to Subpart D and Part 2640. And with that, I'll turn it back over to Dave, who will go over Subparts E through H, although there are Subparts I and J now too.
All righty. We did a fair amount of work on Subpart E. Not a lot of substantive changes, but a fair amount of work. Over the years, we've heard that people sometimes have a hard time training on or interpreting Subpart E. They find it a little confusing, so we tried to make it a little less confusing. So in the overview of Part E, Part 501, we talk about the relationship between the impartiality standards and the criminal conflict of interest law. Obviously, a criminal conflict of interest can also raise questions of impartiality, but we want to make it clear mostly to employees, because you all know this, if you have a criminal conflict of interest, you can't resolve that through an impartiality determination. You have to go through the waiver provisions of 208B, or the waiver provisions of 208. We are maintaining the statement that's been in the reg for a while, that if you have a waiver or an exemption under 208, you don't have a violation of the impartiality standard. Now, this has been a topic of discussion over the years, because simply because something's not a crime, does that mean it's not a good idea not to do it, or that it might be a good idea to exercise judgment on this? And there are two schools of thought on that. I've moved to keeping it the way it is, which we're doing, because of the concern that was raised when it was first thing, and I see it happening more and more, that someone clearly has an exemption, for example, the de minimis exemption. We don't want them to be subjected to stories that, yeah, they're not violating 208, but by acting on something that they had a de minimis financial holding, it creates, I think it looks bad, so it was a violation of 502. We just didn't want to be in that situation. So we're keeping that. That's not a change. We're keeping that in the same, but we are adding a note that addresses some of the concern. And the note actually isn't an ethics note at all. It's a personnel law note that says Yeah, but a supervisor can decide not to assign work to someone because they think it looks bad. They have that authority. The authority to assign work is an inherent authority of a supervisor that, under basic labor law. So if the supervisor or management doesn't think someone should work on something because it would look bad, they have a perfect right to tell people not to do that. And frequently, as the rules, I think we moved away from this, but as the rules were originally envisioned, the agency designee was often supposed to be the supervisor, not an ethics official, or because it's a management determination as you balance those things. But even if the agency designee is not the supervisor, obviously the ethics official can go to the supervisor and say, I think this looks bad. So there is the ability to use some judgment on this using supervisor's inherent authority. Let's move on to 502B, a model of clarity in all regards. 502B is, as we rewrote this, we found out, it's really hard to explain exactly what we're saying here. And so I don't throw shade on the original authors. But we think we've made it a little easier to understand by separating the concept of household, member of household, to a person with whom you have a covered relationship to other stuff that might look bad. So now we have three separate sections: members of household, application of members of the household, application to people who you have a covered relationship with, and then the catch-all. I think you'll find this really useful. For one thing, just totally mechanical. When you refer someone, when you're dealing with someone to a covered relationship, they don't have to read through the part about personal a member of a household and figure out that really doesn't apply to them anyway. It just makes training and giving advice on this easier and clearer. So no substantive change there, but I think a substantial change in the ease of use. And here it is. Yeah, we had the whole OG section doing the wave. And you can see how we've divided here, or maybe you can't see, it's pretty small. Then again, we rewrote or clarified, put new language in the agency designee language just to clarify that these things deal with particular matters involving specific parties, but no substantive change there either. No wave needed. Okay. Impartiality in performing duties. So we have made one substantive change in this, and when the regs were first written in 1992, it distinguished between a appearance of impropriety that could take place if your parent was employed by the party involved in a party matter. But for children, it said it only applied to dependent children and not all children. I'm not sure why that was. I think it might have to do with the demographics of the author. At that point, we were younger, and so we were more thinking of our parents having jobs instead of our kindergartners having jobs. Whatever the reason, it made a distinction. And it's really hard to understand why an adult child creates less of a conflict than an adult parent. So we wanted to harmonize those. And now it just says you have a covered relationship with your employer, the employer of your parents, as well as the employer of your children, all children. We did get some concerns were raised about this, but I want to point out a few things that tend to get overlooked. First of all, this is still a 502 restriction. It still is an encouragement for the employee to consider appearances. It does not say you have to necessarily recuse yourself just because your parent or child is working for someone affected by a party in a party matter. A question was raised, well, now we're going to have to rewrite all our ethics agreements to recuse people in this situation. The answer to that is your ethics agreements currently are not recusing, or we certainly don't require your ethics agreements to recuse people for parents' employers. I don't see any reason why you would have to necessarily stick that in an ethics agreement as it goes to children's employers. And there are no plans to start requiring that in the ethics agreement. Additionally, in the preamble to the regulation, we made it clear that this is a 502 and it does not mandate a recusal. It mandates a consideration by the employee. We also added some examples to make this clear. And this is, I think, really, really good. But we specifically added an example to the regulations where a child is working for someone with whom a covered which is involved in a party matter. So yeah, the employer is involved in a party matter that the employee is working on. And we gave an example where the employee would not need to recuse themselves because it was reasonable to conclude that it would not cause another person to question their impartiality. Kind of drive the point home, we have an earlier example where someone did have to recuse because their parent was involved. So we're treating those two similarly. We also added another example for a catch-all, which is a party matter where the person's best friend is actually presenting the case to the employee. And we said, yeah, that's really not covered, but that's a good chance for a person to reasonably conclude that a person might question their impartiality. As I said before, if you're worried about training, we've delayed the effective date for 90 days after publication so that you'll have time to incorporate that into your training if you think that's necessary in the situations you're faced with. On to 503. 503, so we're going to take a little time on 503 primarily because I discovered in running through this presentation, it's really hard to explain what we're doing here without going through what 503 requires and all that. As I was doing it, my staff was just kind of shaking their heads. So we tried to improve on that. Okay, just a reminder. What 503 says, it's kind of complicated. It provides that if you get a payment of over $10,000 from your former employer, after your former employer becomes aware that you're getting a job with the government, but before you join the government, and that payment is not made pursuant to a qualified program, you have to recuse yourself for 2 years from any party matters involving your former employer. Pretty long. And we had, and then the reg goes on to explain what a written policy is. We made a few that either a qualified program either has to be done in accordance with a written policy or a history of similar payments being made. So we made a couple little changes in that area. First, we said, even if the written policy provides for the payment, if the written policy says we only make this payment to government employees, that doesn't make it. That's not going to be allowed. Interestingly, when reading through the 1992 preamble, it was, we don't think we need to deal with that because, frankly, it's inconceivable that any agency, that anyone would put that kind of thing in writing, in a written policy. We discovered that inconceivable may not have meant what we thought it meant. And we found some people actually doing that. So we said, nope, that's not a written policy we're going to recognize as an exception. And we also said, and this is really for ease and consistency. By the way, if you have a written policy that says you can't get this, for example, the most common one, if you leave before your stocks vest, you forfeit them. If that's the policy, don't come back to us and say, yeah, but we're letting this guy keep it because we always do that. Yeah, you're stuck with the written policy when you have it in the written policy. So those are the changes we made to that. Additionally, you probably missed it. Maybe you didn't miss it. The regulation said If you get the payment after they know you're going to get a job, but before you take the job, it's prohibited. Well, what about if you get the payment after you take the job? We've changed the regulation to delete the concept that it has to be before you take the job. The reason it was in there in the first place is because this was originally written as to fix what we envisioned as a hole in 209. There was a court case that said it's not a 209 violation if someone gives you a bunch of money before you come into government, because 209 only applies to government employees. And so we put in this provision in order to kind of fix that hole. Now 503 applies to those. Of course, if you get the payment after you're in government, it also raises some serious 209 questions, or can raise serious 209 questions. So not only does the 503 apply, but remember, you have to look at if there's a 209 issue when that happens. Seeking employment. As I said, we totally rewrote this section, Subpart F, after the Stock Act, so we've not rewritten it again. Why can't he do all sections like that? Subpart G, misuse of position. Again, no substantive change here, just some good, I think, practical training things. First, well, substantive change, but consistent with what we've always been advising. There was a little glitch in the letter of recommendation ones, which many of you used to work with, because it only talked about letters of recommendation for employment. And when law students were asking for admission letters and things like that, it wasn't literally covered. We've generally allowed people to do that anyway. This change makes it clear that the letters of recommendation are not limited to employment. They can be for other things as well. But it also expands it to say, the letter of recommendation provision also applies to things other than letters. If you're writing an email, or if you're using your official position to make a recommendation in other ways, it's still, just because you're not doing a formal letter, you still can't use your title inappropriately. The other area that we've struggled with, or have struggled with in the past, and there was a question of how does this whole thing about using your title apply to social media? Can you put your title in the heading? We've given lots of advice on this. We have a legal advisory on this, but we thought, since we did a legal advisory, let's put that concept into the regulation. It's not a violation of Subpart G if you put your job title in your biographical information, and then talk about stuff related to your agency in your post. Now, it can be a violation if you do it improperly. That is all covered by the legal advisory. Moving on to outside activity. Here we're incorporating, again, the ministerial changes that Seth has talked about. The other thing we've done in this, two other things we've done in this, the concept of compensation. Again, a historical reason is originally OG said travel expenses are always compensation, and the Supreme Court came out and said, well, since your laws allow employees to accept travel expenses when they're speaking on behalf of the government in an official capacity, read saying what the government likes, you can't prohibit them from having travel expenses paid if they happen to be saying something the government doesn't like. And so we said, well, you're wrong, Supreme Court, but we'll follow you. In that case, interestingly, the plaintiffs in that case were career employees, so the relief was only granted to career employees. But at any rate, so we had this statement in there saying travel expenses are compensation, but then we added a statement later to deal with the Supreme Court case that said, but if you're not a non-career employee, travel expenses aren't compensation. Now it's just switched around more intuitively. Travel expenses are not compensation unless you are a career non-employee. It just reads much better. In the speaking, teaching, and writing area, we've always given the advice that when you look at what does it mean to receive compensation, when do you receive compensation because you're prohibited from receiving compensation for speaking, teaching, and writing that's related to your official duties. Receive is determined by when you did the speaking, teaching, and writing. So, and that's always been the advice in Seth's legal advisories. Now it's in the regulation. That's what we mean by receive. When did you do the speaking, teaching, and writing? So if you are speaking, teaching, and writing while you're a government employee, you can't avoid this restriction just by deferring payments until after you leave. Similarly, if you do speaking, teaching, and writing before you're a government employee, but you don't get the money until after you're a government employee, the receipt is attributed to the time when you did the work. And that's consistent with the advice we've always been given. Now it's in the regulation. Subpart I, we decided there were enough related statutory authorities already in the regulation, so we didn't add any. I've always felt that if the alphabet's not long enough to cover it, you've probably got too many. So nothing added there. And Subpart J, the legal expense fund regulation, is not part of this revision because it was done while we were doing this revision and we're not. So when you see the publication, Subpart J is not in it because it's not being changed. And with that, we move to questions. So